Thank you, Priya ma'am. Good morning, all. Sedition is a very contemporarily relevant topic of discussion in such a crucial timeline of vast changes in social and political system of our country. As we all know that India is a sovereign, socialist, secular, democratic republic nation, and maintenance of unity and integrity of the nation should be a duty for every citizen of this country. Unfortunately, the meaning of secularism and freedom of speech and expression is misused in a fashionable manner to strike at the base of a national integrity. So once again, good morning to one and all present for this webinar. Respected management, speaker, principal, faculties, and the participants. I heartily welcome you and thank you all for making yourself free for logging in to be a part of this informative webinar on sedition law in a democratic country. We request all the participants to maintain decorum all through the sessions and ensure that your video and audios are muted for an enriching learning experience. Okay, let's not wait anymore. Let's move ahead with this exciting webinar. And if you miss anything because of network or internet issues, please do not worry. We will be sending around the recording when it's made available on our Soundarya Institution's YouTube channel. Now, I request Jyoti, student of Soundarya College of Law, to introduce the speaker of today's webinar. Over to you, Jyoti.
Thank you, Ravi. Everybody has a right to be defended, and every lawyer has a duty to defend accused. Lawyers are operators to tall bridges which anyone in search of justice must pass. On behalf of our management and our college, it gives me immense pleasure to welcome our today's resource person, High Court Advocate Abhilesh J. Sir completed BA LLB from Bangalore Institute of Legal Studies in 2012. He started courtroom practice in 2012 under the guidance of Mr. Gangadhara Aital and worked with designated senior advocate Mr. S. Srivastava. He started independent chamber practice in 2015. He is specialized in dispute resolution, having gathered 8 years of experience in handling various types of litigations, corporate and commercial matters, writ petition, arbitration, consumer dispute, and white-collar crimes. He represented various MNCs and institutions before Magistrate Court, Civil Court, High Court, and Supreme Court of India. Today, he is with us to explain about the sedition law in democratic country. Over to you, Abhilesh, sir.
Thank you. Good morning, everyone who are present here today. So this is Abhilesh, and thanks for the nice introduction. So today, one of the most important topics, which is widely debated across the country and also in the international arena, is with regard to sedition. While several other countries like New Zealand, Australia, UK, as well as USA have abolished this particular law, few countries like India, as well as Malaysia, they still, including Nigeria, they have retained this sedition law. So there's a wide debate as to whether sedition as such should be penalized as under 124A in India, or if it should not be. Now, let us first understand what is the history and the root behind this particular sedition law. Sedition law finds place in section 124A of the Indian Penal Code. A brief background as to when and how this particular law came into existence would also be equally important. First, let me start with Black's Law Dictionary as to the definition of what a sedition would basically mean. To read what the Black's Law Dictionary would actually say is an agreement, communication, or other preliminary activity aimed at inciting treason or some lesser commotion against public authority. Advocacy aimed at inciting or producing and likely to produce or produce imminent lawless action. So there are few terms that have been used here that would like require our immediate attention. That is incitement. The second aspect being produced. Okay. Then the threat or the incitement has to be imminent, meaning to say that it has to have an immediate impact, the outcome of which would result in a lawless action, and it would also result in violence. These are the basic principles which would actually pave way for this sedition. Okay, so let's say if I actually advocate some aspect in general and which would not immediately incite any violence or disrupt the public order, in that event it cannot be termed as sedition. Now let us actually come to section 124A of the Indian Penal Code. Let me read 124A for you all. Whoever by words, either spoken or written, or by signs, or by visible representation, or otherwise brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years, to which fine may be added, or with fine. So there are few aspects that needs consideration here. The first aspect being any words that are actually spoken, written, signs, or visible representation. All of these would express, if in case it if in case it attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government of India. This is something really crucial, I would mention, because government established by law would mean to say, especially in a country like India, a democratic country, where a government is formed through elections, the representative of the people assumes the government and he presides over. While they do it, any person who aims or who targets at the government formed through elections to their dissatisfaction or to dethrone them, and they incite violence. That is the most important aspect here. Who have to incitement of violence should be there. Then that person can be punished with life imprisonment or with fine and imprisonment extending to a period of 3 years. Now, if you kindly see, when did this particular provision, section 124A of the Indian Penal Code, came into the Indian Penal Code is in the year 1870. As you all would also recollect, Indian Penal Code came to be enacted in the year 1860, whereas section 124A was not part of the first enactment, that is on the year 1860. Through an amendment in the year 1870, this particular provision came into existence. Now, who is the author of this particular provision of law? That is sedition. Who brought this concept of sedition? The concept of sedition was existing in England back in the year 1590. In the history, it traces like people were being prosecuted for opposing the government and trying to dethrone them, or even, let's say, like inciting violence. It is back in the year 1590 that people were being tried in England for sedition. Now, the author of this particular provision, 124A, is Lord Macaulay, Thomas Babington Macaulay. He finished his law degree at the Cambridge University, and thereafter he was sent to India to help manage the legal affairs in India. Having come here in the year 1837, Lord Macaulay completed drafting of the Indian Penal Code. Having completed drafting of the Indian Penal Code, it was actually not enacted right until 1860. Now, one other important aspect that needs to be mentioned here is, as on 1870, when this particular provision, section 124A, came to be amended and included in the Indian Penal Code, it was a non-cognizable offense, meaning to say that to arrest a person as under sedition, order from the magistrate was mandatory. The police or the investigating authority could not have effectuated an arrest without approval from the magistrate. However, post-independence, that is in the year 1973, this particular offense came to be classified as a cognizable offense. That is well past the independence. 1973. What happens in 1973 which necessitated the offense to be classified as a cognizable offense, wherein investigating authority could effectuate an arrest even without the order from the magistrate. So I would again go back to trace the history as to why, what was the reason that it was originally not part of 124A, was originally not part of the Indian Penal Code. Subsequently, what compelled implementation of 124A as on 1870? The reason being the Wahhabi movement. Wahhabi movement, as you all would also know, is a socio-religious reform. It's a movement that was vigorously campaigned at a movement to bring about a socio-religious reform against the British. We were being governed by the British. Therefore, there was this Wahhabi movement which was actively taking part across India to bring about a closure or trying to oppose the ideologies of the British. This particular movement actually necessitated the British to bring about a curb with regard to all of similar movements happening across the country. So this compelled the British to actually come about and carry on this amendment and bring about section 124A into enactment. Now, the first reported judgment, a person who has been tried under the sedition law in India, is Mr. Jogendra Chandra Bose. The trial actually commenced in the year 1891, whereas Mr. Jogendra Chandra Bose was the author of a newspaper daily called as Bangobasi. He actually criticized the British for bringing about a bill. The bill is Age of Consent Bill. This particular bill was actually opposed and severely criticized by Mr. Jogendra Chandra Bose in his newspaper Bangobasi for posing a threat to practice of religion. This was severely criticized in his newspaper, the bill, and immediately the British set this particular law into motion and they convicted Mr. Jogendra Chandra Bose as under sedition law. The second major case that one would want to notice is the case of Bal Gangadhar Tilak, where he was also tried for sedition. The reason why he was actually tried for sedition, it also the present condition. I'll slightly deviate for a minute. As of now, Epidemic Diseases Act is in force, and it would this particular enactment would kind of find its place back in the year 1897. And the reason that it came to be enacted was because of famine as well as bubonic plague that had actually struck Pune in the year 1896. India was going through a very rough patch where like famine was highly predominant across the country, as well as bubonic plague struck Pune in the year 1897. That is when the Epidemics Act came into force, came to be enacted. And in the background of this particular pandemic, the same Epidemic Diseases Act has also been enforced. Now, the reason I actually mention these two aspects is the British had actually continued to collect land revenue even during the famine, as well as when the bubonic plague had actually struck Pune. This particular fact was severely criticized by Mr. Bal Gangadhar Tilak in his newspaper, that is Kesari. He had carried out articles criticizing the draconian pattern in which land revenue was being collected by the British in spite of the country witnessing famine. At which point in time, the British government decides to slap Mr. Bal Gangadhar Tilak with a sedition charge. In this charges, Mr. Bal Gangadhar Tilak pleads innocence. He says, I am not guilty of this particular offense for the simple reason that I am showing the people that what is the present scenario, what is being carried out. Thereafter, trial takes place. There are few interesting aspects here in this particular trial as well. Mr. Bal Gangadhar Tilak was being represented by Dinsha Davar. So he was his advocate representing him before the court of law to plead that his client, Mr. Bal Gangadhar Tilak, was not guilty of committing any sedition as such. So the background, or what do I the reason that he says that he is expressing his dissent, or he is expressing the fact or criticizing the government's policy of imposing taxes, is uncalled for. That criticism has been highlighted. Therefore, he pleads that he is not guilty. The important aspect that one has to notice here is the judgment that has been passed, wherein Mr. Bal Gangadhar Tilak was sent to 18 months in prison. He was convicted of sedition and he was sentenced to 18 months of prison. The reason behind this, one important observation that we need to notice in this particular judgment is the court observes disaffection towards the government established by law that would also amount to sedition. Now, again, let's kindly go back to 124A. What it basically says is, whoever by words, either spoken or written, or by signs or visible representation or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law. Earlier, this particular aspect, that is to excite disaffection towards the government established by law, was also not present in the original 124A. That is the enactment, the amendment that was brought in. This disaffectionate, exciting disaffection towards to excite disaffection towards the government established by law was subsequently included into this section, that is 124A, because of this particular judgment. Now, if you also notice, Mr. Bal Gangadhar Tilak was once again tried for sedition, and once again he was also convicted for sedition. The interesting aspect here is Mr. Dinsha Davar, who represented Mr. Bal Gangadhar Tilak in his first case, in his fight against sedition. He is the presiding officer, or he is the judge when the second case comes to be tried. Mr. Dinsha Davar was the judge when he slapped Mr. Bal Gangadhar Tilak with 6 years of rigorous imprisonment. So what was this second case regarding? Why was Mr. Bal Gangadhar Tilak tried for the second time under sedition? This happened in the year 1902 with the partition of Bengal. where two English women who participated in a seminar or in an addressing came to be killed. So there was no direct, this particular article was again covered in the daily newspaper that was published by Mr. Balgangadhar Tilak, Kesari, where there was mention with regard to killing of these two English women. Okay, so what happens there is Mr. Balgangadhar Tilak's house was actually searched, and there was two books that was actually found. It did not even have any reference or like direct mentioning to the explosives that was actually used in the killing of the two English women. But what happens is there is only a reference. There was not books. There were no books with regarding explosives. There are only references to explosives that were there, that was found in the house of Mr. Balgangadhar Tilak. Merely on this particular aspect, Mr. Balgangadhar Tilak was actually convicted for sedition, and he was sentenced to 6 years imprisonment. In fact, Mr. Dinshaw Davar, he makes a note that it's a disgrace. The newspaper publication was a disgrace, and his opinions, that is opinion of Mr. Balgangadhar Tilak, was a disgrace to the country. These were the exact observations that was actually being made by Dinshaw Davar, who represented Mr. Balgangadhar Tilak in his first case for sedition. Now, few other prominent leaders of the country have also been tried under this particular sedition law. So, in a country like India, where Article 19(1)(a) would give absolute liberty subject to state's imposition, there are some restrictions, as you all would also know, that have been imposed by the state in making or governing the freedom of speech. Let me also read Article 19(1)(a) as well as 19(2). Under what grounds a person's freedom of speech could be curtailed or not curtailed or restricted. Okay. So 19(1)(a), protection of certain rights regarding freedom of speech, etc. All citizens shall have the right to freedom of speech and expression. Now, this is subject to certain regulations. What are those regulations? 19(1)(2). Nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes a reasonable restriction on the exercise of the right conferred by the said subclause in the interest of sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. These are the 8 conditions through which a state could reasonably restrict a citizen's right for freedom of speech. Now, one other aspect that would require a special mention here is the judgments through which this particular public order, in fact, public order was not part of Article 19 subclause 2 when it was enacted. 19 subclause 2, public order came to be included in the Constitution in 19 subclause 2, when in the first amendment carried out on 1951, wherein the Constitution of India came to be amended and public order came to be mentioned. The reason behind this is the judgment of Ramesh Thapar versus State of Madras, which is of the year 1950. To this particular case, public order came to be included. So what had actually happened is there was widespread addressing that was actually being taken place across the country, through which Mr. Ramesh Thapar was tried for sedition. He challenged, and he was also convicted for sedition. He challenged this particular judgment of the Madras High Court before the Supreme Court, and he said advocacy of dissent as such, which would not immediately incite any disorder in the public, should not be tried. But again, the appeal actually failed, and through an amendment, this particular aspect, that is like public order, came to be included in the 19th Clause 2. Now, let me also make a mention to the prominent leader, wherein like Mr. Mahatma Gandhi came to be tried under sedition law. So this was with regard to non-cooperation movement as against the British. So Mr. Gandhi was also author of several articles that was being published in Young India, a newspaper article, wherein he was widely canvassing that the people should not cooperate with the government with regard to implementation of certain laws. So if you also see, one other interesting aspect here is Bal Gangadhar Tilak, in both his charges, in both his trials, had pleaded not guilty. Whereas Mr. Gandhi, in his trial, when the charges were being framed as against him, he pleaded guilty. He said a citizen would have absolutely all rights to criticize the government for implementing draconian laws. And it is this particular non-cooperation movement which actually led to his conviction in this particular matter. Now, a government which is repressive as well as arrogant towards its citizen, Mr. Gandhi says a citizen would have all the rights to oppose this particular government, express their opinion, telling that yes, the government's law, the mechanism through which law is being implemented, is repressive or arrogant. So, Justice Broomfield, he sentenced Mr. Gandhi for 6 years jail period for him pleading guilty. And it's also pertinent to mention here that Broomfield mentioned the fact that he would be the first person and most happiest person if the British government would actually were to release Mr. Gandhi prior to his serving the entire term of 6 years imprisonment. Now, few other important aspects that needs a consideration as to how this particular law has actually come into force, or how this has evolved from 1870 right until now, that is like 2021. So what happened? Because if you could also notice the fact that a law which was originally non-cognizable, as at the time of post-independence, the same law has been made into a cognizable offense. What necessitated that to happen? Now, if you also see our Constituent Assembly, 9/12 to 1946, when they actually formulated, Mr. Sardar Vallabhbhai Patel was the head of the committee. There's a lot of discussion with regard to having sedition in our Indian Constitution. There were people canvassing sedition that should have been part of the Indian Constitution, and there were people who were against the aspect of sedition law being implemented into the Indian Constitution. That is where a reasonable restriction, that is 19 subclause 2, finds is based. So it was decided that they would rather have reasonable restriction that could be imposed by the state with regard to giving absolutely unfettered right of freedom of speech and expression. That is how these 8 restrictions that you could find as under 19 subclause 2 came into existence. So the people who were actually supporting this sedition law would be two people who vigorously said that yes, sedition should find its place in our Indian constitution, would be Sardar Vallabhbhai Patel as well as C. Rajagopalachari. Both of them canvassed that yes, sedition should find place in the Indian constitution. And there were two people who were severely opposing this. That is one, Mr. K. M. Munshi as well as Somnath Lahari. Both of them opposed the fact that Indian constitution should not have any restriction when it comes to freedom of speech. Then finally, Indian constitution did not see sedition finding its base in the constitution, whereas the Indian Penal Code still continued to retain sedition as under 124A. Now, there are a few other interesting case laws where the Supreme Court has had the occasion to test whether sedition law is unconstitutional or not. Landmark judgments like Kedarnath Singh versus the state of Bihar, as well as Ram Manohar Lohia. So these two cases were in of the year, like Ram Manohar Lohia's case would be a stepping stone for the Supreme Court to lay down or rather test sedition law, that is 124A, whether it's being constitutional or not in the year 1962. In the Kedarnath's judgment, the Supreme Court upheld section 124A and it said that yes, it is constitutional in the year 1962. The main reason behind why the Supreme Court held that section 124A is constitutional was they also made an observation as far as an expression of opinion by a citizen would not incite violence or would not plant in the people an idea to resort to lawlessness, that would actually mean to say a person cannot be tried under sedition. Therefore, any formal expression of opinion, speech, writing which would not incite violence into the people. And one important aspect here is imminence. It has to immediately result in people resorting to public violence, resorting to lawlessness. That would amount to sedition, and there is absolute requirement for this particular provision, and they held that 124A was not violative of fundamental rights guaranteed under 19(1)A of the Indian Constitution. Next judgment that would also be of prime prominence to mention here is Balwant Singh versus the state of Punjab, as well as Shreya Singhal's case. So Shreya Singhal's case, as you all would know, post demise of Bal Thackeray, a lady had carried out an article. Shiv Sena had actually called for a statewide bandh on the account of death of Mr. Bal Thackeray. So there were two people who were actually tried here for sedition, and what had happened here was, what exactly did this woman do is, they mentioned, one lady mentions that yes, what is the need for calling in for a nationwide or a statewide bandh on the occasion of death of Bal Thackeray. This particular post was also liked by one other lady who also came to be tried, who also came to be booked and tried under 124A. Offences under 66A of the Information Technology Act was booked along with 124A. A law student, Shreya Singhal, she approaches the Supreme Court stating that expression of dissent would not amount to immediate public violence, and she also challenged the constitutional validity of 66A of the Information Technology Act. The Supreme Court went ahead, they quashed the proceedings. Justice Rohinton Fali Nariman, in his judgment, declared that Section 66A as unconstitutional, and both these women were actually acquitted of this particular offense. Now, there are certain aspects that also needs consideration. So we have been having sedition law for like a prolonged period of time. Is there really a requirement for this particular law to be in existence? Also, if you were to trace the history and also appreciate the fact that this is a law which was brought in by the England, the British India, as during the period of British India, where this was primarily targeted at people waging war or expressing dissent as against the British India in their fight for freedom. Is there really a requirement of a law to continue to be in existence even today? So one aspect that needs consideration, or if I have to talk in favor of why this particular law still needs to be in existence even at this point in time, I'd like to point out to the fact that geographical condition of India and of several states where there is even till date, there is presence of Naxalites, Maoists, as well as anti-national activists that are being taken place. If we do not curb this particular practice of where Naxals, anti-terrorists, anti-national activities, as well as Maoism, where their foundation, they derive energy by mentioning the fact or inciting into the people to resort to violence. They incite people, they come about brainwashing people, trying to resort to violence. How do they do that? They do it through publications, word of mouth, expression. They use 191A as a channel to brainwash people into resorting to public violence. Thereby, there might be or there would be a requirement for retaining this particular law in India. However, if you would also see how this particular law has been utilized, it has merely fallen into the hands of the government, of political parties, where they use it to curb the people's expression. Or any person, let's say I form a government, and the very basic integrity or like the structure of our country being democratic is I have the right to criticize a person for his implementation or his ideologies. If this very basic fundamental aspect is being deprived by the government because of their inefficiency in running the government, would this amount to sedition? So what the political parties have been doing is, any person who opposes the ideology or who criticizes the policies of the government, a government can only get better with active criticism and opinion by every citizen. To what extent can this particular criticism be made? Now, if you also see the aspect, as I mentioned, it has sedition law of late has been used by the political parties to fulfill their agendas. One example that I could actually give. So let's say I form a government, and this government comes up with policies which is being opposed by few journalists, few citizens. They carry out posts telling Abhilesh has come out with this particular policy, which is completely uncalled for. It would not have any sense, and it is against the people. Now, one immediate means through which I can actually shut that person up would be using this as a weapon, using the sedition as a weapon to actually ensure that he is inciting violence into the people. There have been instances where a 9-year-old student has in fact been tried for sedition. And this happens in Karnataka, where in a play, the child was carrying a role, the character as that resembling the Prime Minister, where a shoe was being hurled at the Prime Minister. Shockingly, this particular 9-year-old child was charged. The mother as well as the teacher of this particular school was actually charged for sedition, was being tried for sedition. Now that's where the question arises. We've had journalists, Arundhati Roy, in fact recently Miss Disha Ravi, she was also being tried for sedition. Why exactly was Disha Ravi tried for sedition? If you were to see, Farmers' Bill was widely opposed across the country. And what exactly did Disha Ravi do? Disha Ravi, it is alleged, I mentioned that it is alleged that she formulated a toolkit through which a protester or like a person, by going through this particular toolkit, was able to protest against the farmers' bill being implemented. It was supporting it. Therefore, the government, what they did was to try Disha Ravi, they mentioned that it was a constructive sedition, meaning to say that Disha Ravi, by virtue of this particular toolkit, was inciting violence amongst public. She was not expressing her dissent, or she was not criticizing the government in a progressive way, but a regressive way, thereby inciting violence across the country. On this ground, Disha Ravi came to be tried, and trial is underway. So as Kanhaiya Kumar, so he again is being tried for sedition. We have had several sedition charges being levied. Now, if you also were to analyze, if all of these cases have been resulting in conviction of these people, whether they have been successful in telling, yes, a person has, let's say I have been accused of sedition charges, has it culminated into a conviction? No. If you were to see the statistics regarding this, National Crime Records Bureau would reflect right until 2019, only 3.3% is the conviction rate of all the people. So there have been several cases that have been registered. On an average, 30 to 50 cases in a year gets registered as against citizens of India for sedition under this particular provision. Now, the conviction rate, if you were to compare that, it's a paltry sum of 3.3%. How successful have they been? Because there's a direct conflict between 19(1)(a) of the Indian Constitution and Section 124(a) of the Indian Penal Code. Now, if you'd also, there's one other question that might also arise. Is this the only provision which would restrict a person from freedom of speech? Is there absolutely no other law which would, or no other provision in law which would have some restrictions imposed upon the citizens and who would adopt to resorting to violence? Yes, there are few other provisions of law as under IPC, as well as one other recent enactment, Unlawful Activity Prevention Act. So UAPA, those enactments, I would say, widely caters to the same law, meaning to say that any person who would incite violence would also be tried under UAPA, as well as few other provisions of the Indian Penal Code. Now, this is where the conflict arises. Is there really a requirement to continue with the sedition law as such? As I mentioned, because of geographical conditions, at few places, yes, because of Naxal activities, Maoism, anti-national activities, there might be a requirement for this particular law to be there. But should it confer any restriction upon the fundamental right that is being guaranteed under Article 19(1)(a)? I would say no. Why would one person tell that there is absolutely no requirement for 124(a)? A person could actually say that there is absolutely no requirement for 124(a) for the simple reason that it is being misused by the governments. 1973 is when this particular offense was classified as cognizable, because then 1973 the Congress was ruling the country, where few articles, few criticism was being made as against the ruling party at that point in time. The government, I would say, in an arbitrary manner, classified this offense only to ensure that there was no fair criticism of the government. That is where this particular law came to be classified as a cognizable offense. Now, if you would also see what's the Law Commission report would say regarding this particular aspect, whether sedition law should continue to be in a country like India, where active participation of all citizens is always called for, active criticism is always called for, dissent is called for. It is this dissent and disagreement which would set forth a primary example, or which is the foundation stone for having an effective government in implementation of policies. If I'm not even permitted to actually have my opinion expressed in my own fashion, could this be termed a dissent leading to violence? The only classification is this: a fine line is being drawn between a person who could be charged under sedition and a person who could not be charged or tried for sedition. Violence, public violence. If I incite, if my intention is to provoke people, incite people to resort to violence, in that event, yes, I am liable to be prosecuted under sedition. If I am only expressing the fact I am not in agreement with the policies of the government, yes, it cannot be termed as sedition. It is my right. It is safeguarded by the government, by the Indian Constitution, that I have my free will to express. I can express my intention. I can express the fact that I am not in agreement with the policies brought in by the government. Now, in a country like India, as I also mentioned, a democratic country, India is also signatories to several international covenants which would ensure its citizens freedom of speech. Freedom of speech and sedition law. This would, I would say, is a little contradictory, meaning to say that by virtue of India being signatory to international covenants, like International Covenant on Civil and Political Rights, this protects the freedom of expression. I can express the fact that I'm not in agreement with the government policies. Whereas the same existence of 124A would come as an impediment where I could be tried for no fault of mine, only for expressing my dissent with the government. This debate with regard to retaining the sedition law or not to retain has been widely debated. The Law Commission report would also suggest that there is a requirement for this law, that is sedition, to be abolished, or there is a requirement for this particular law to be revisited as to whether a person could be penalized as under 124A. Now, few other aspects that might also be mentioned here is what is the international standing at this point in time. UK, as recently as 2009, they abolished sedition law. They said it is against the constitutional rights of the parties. It goes against the fundamental principles wherein parties would want to express their dissent, and they abolished sedition, as well as New Zealand, Australia, including Indonesia, has actually abolished, as well as US has also abolished sedition. Countries like Nigeria, India, as well as Malaysia, they continue to have sedition laws. Now, the recent three-bench judge has been formed, a constitutional bench, wherein they intend to look into the fact whether sedition should continue in a country like India. That is being discussed. You would also get an outcome on the fact whether sedition law should continue or not. So a fair criticism of the government could never be termed as inciting violence. There should always be room for people to express themselves. Expression as well as dissent is the very fundamental principle that would be required in a country like India. And I would definitely canvass the fact that sedition law would bring about unconstitutional or like an unparliamentary restriction on my expression of rights. Therefore, I would personally suggest, or like my personal take on whether sedition law should exist or not, I would say no, it should not exist, because there are provisions in law. UAPA enactment is there. There are other provisions in the Indian Penal Code itself catering to all of these activities where there is incitement of violence on a public platform. Therefore, my take on the entire aspect is sedition law should not continue in a democratic country where freedom of speech and expression is guaranteed by the Indian Constitution. This would be my observations. If any of the students would have any queries, I'd be willing to take them.
Now we would be so we have some question and answers regarding to the to this topic. It was a very enlightening topic as well. So first question we are picking up is, has social media become a tool for sedition now? What is your valuable inputs on this?
Yes, so this would in fact again refer back to Shreya Singhal's case, where one lady had put up a post on social media. So social media, yes, a 66A Information Technology Act has been declared unconstitutional. If one were to analyze if social media could be used as a platform wherein this sedition could be used as a tool, yes, definitely it could be used as a tool. We are in an era where technology is everything. We are in a place where each and every individual has come on a public platform using social media to express his or her opinion. This particular expression, I would definitely contend that is very well safeguarded as under Article 19(1)(a) of the Indian Constitution. Is sedition law 124A being used as a tool? Yes, definitely it is being used as a tool. Because just imagine the volume in which people could actually express themselves. Earlier, the masses could not express their opinions as freely, as unfettered as at present time because of the existence of social media. Sedition law, in fact, Disha Ravi, lot of people, in fact, I can name Arundhati Roy, Kanaya Kumar, Umar Khalid. All of these people, in fact, have been tried because of their presence amongst the general public. It is the number of followers that they actually command on social media platforms. Any expression of their opinion influences the masses. This particular influence is being also seen as a threat by government, or I would say inefficient governments. That is the reason that they are being tried, where this particular 124A is being used as a tool, or rather as used as a weapon to ensure that people do not express their opinions on a social platform, thereby influencing other people. That would be my answer.
So one more question. Okay. Can we say that section 153A of IPC is also a sedition?
See, 153A has also been there. It was also included into the Indian Penal Code through an amendment. Okay, promoting enmity between different groups on grounds of religion, race, place of birth, residence. So what is the distinction that one could actually draw between 153A as well as 124A? Now, one thing that I would like to point out here is when I mentioned earlier in the addressing that there are equivalent provisions which would specifically cater to incitement of certain offenses. I was also referring to section 153A, where a person is being deprived or he's being accused just because of his background, because of place of birth, his race, religion. This is already covered and it is already punishable as under the Indian Penal Code. Now, 124A as 153A, what would be the requirement to retain 124A when it is specifically being targeted by the governments or the inefficient governments? There is already in place, that is like 153A is exhaustively covering similar aspects. 153A in relation or read along with UAPA and few other provisions of IPC itself would in fact classify this as an offense, and they have also elaborately specified it with regard to the punishment that would be leviable upon the person who is proven guilty of this particular offense. So, important aspect that if you would also notice, 153A is also a non-cognizable offense where like a magistrate's permission might be required for carrying out an arrest. The punishment shall be for a period of 3 years or with fine or with both as under 153A. Whereas 124A is being used as a weapon only because of the reason it is a cognizable offense, where the investigating authority or the police could actually carry out an arrest even without a warrant being issued by the magistrate. That's the reason I would definitely contend that yes, 153A more or less covers the most important aspects that 124A would also cover. Therefore, there would still be an argument that would say that 124A need not be necessary at this point in time.
Okay, so thank you, sir. There are other questions and we will send it to you as a query. Now I request Ravi to take over.
Thank you, Priya ma'am. Thank you, sir, for sharing inputs on this. And it is indeed an honor and a privilege to know the facts and information that you shared about sedition law. And okay, so now I would request Arjun, student of Soundarya College of Law, to extend the vote of thanks. Over to you, Arjun.
Thank you, Ravi. Gratitude is not only the greatest of virtues, but the parent of all others. These are the words from Marcus Tullius Cicero. First and foremost, my extreme gratitude towards our management for permitting us to organize this webinar, Sedition Law in a Democratic Country. I would like to thank our guest speaker, Advocate Abhilesh J, eminent advocate from High Courts and Supreme Court of India, who has given us immense knowledge about the sedition law and its importance in a democratic country like India. Thank you, sir. My heartfelt thanks to our beloved principal, Dr. Jayashree, Principal, Soundarya College of Law, for extending her support as always. Thank you, ma'am. I would like to thank our faculty convener, Ms. Priya Makanda, ma'am, co-conveners, Ms. Claudia Nath, ma'am, Ms. Monisha, ma'am, and Mr. Vinay Ravishankar, sir, for making this webinar a great success. Thank you, teachers. I would also like to thank Mr. Prasad, sir, IT department, for running this webinar smoothly. Thank you, sir. I express my gratitude to the student coordinators and my friends, Mr. B.K. Ravi and Ms. Y. Nagar Jyoti, for the successful conduction of this webinar. Thank you, team. Last but not the least, I thank all the participants for their